Hello, it's Joanna Toch with the Family Law Cafe podcast. Today I have Oliver with me. Oliver, introduce yourself. What do you do?
Joanna, thanks so much for having me. My name is Oliver Al-Falah. I'm a specialist criminal and regulatory lawyer.
Yeah. So how did you get into this world of crime?
Always wanting to be a jury advocate, actually.
Yeah.
From as soon as I started my law degree, I thought actually that's what I want to do as opposed to sitting behind a desk.
Yeah.
Went off and did my bar course.
Yeah.
And then grew to love not only the criminal side of things, but finally wanting to deal with clients on a day-to-day basis as opposed to being in court. So then ultimately my emphasis shifted from advocacy to actually building cases, which is what I do now.
So do you take the case right from the beginning and do the advocacy as well?
Certainly right from the beginning.
Yeah.
I do some advocacy.
Yeah.
But if it's long trials, then I will instruct specialist counsel.
Yeah, you can't be everywhere doing everything.
Correct.
Okay, so quite similar to me. I started off as a criminal barrister. I did that for 8 years, and I was mixing it in with family. And then I found I didn't want to do. Well, the reason I did family was because it was just kind of quicker. I mean, completely honest. I was finished by 2:30. Like, okay, I'm done. I'm home. I enjoyed doing the trials, but I found I was just a bit stressy about it. Also, the other thing is you have to stand up all the time. So I got a bit tired. I want to do more of a written practice. So that's so shallow. But do you find by doing the beginning and the paperwork, is that more satisfying for you? Because I do that in family. I do the beginning, do some advocacy, and I like to do the whole thing.
That's certainly an element.
Yeah.
But what I really enjoy most is building the relationship with the client and having control of the case.
Yeah.
And I think that idea of forming a strategy right from the outset is so important for them.
Yeah.
But also for me, I like to think that's what I'm good at.
Yeah.
And even that does, of course, come down to if you need to instruct counsel, choosing the right one.
Yeah.
Not only for the case, but also for the client, because relationship matters.
Yeah.
And if you have that connection with them and with counsel too, then ultimately you're going to get a better result.
And did you ever feel that those early days where you were doing a trial, like, oh, if this had been done in this way, we could have got a better outcome? Because that's how I felt.
I was really fortunate that I started off at a fantastic firm.
Yeah.
And before I went out on my own, I only practiced at really good firms. So I was always very fortunate to have that real kind of high level of preparation.
Yeah.
So no, I haven't felt that personally.
Yeah.
But I do know people who have.
Yeah, I think it was because I was, a classic. I mean, it's quite a long time ago now, and a chambers where you would get something and think, yeah, if this had been done earlier, or if this had been prepared differently. So I always wanted more control.
I should say that a lot of my cases are referred to me for clients who have already had lawyers.
Yeah.
And then, yes, you can appreciate the difference that you can make or you could have made.
Yeah.
But most of the times you're able to correct any I won't go as far as failures.
Yeah.
But not quite doing what they need to do.
Yeah. So, and what's the importance of getting early advice, would you say, to people?
That idea of strategy. Mm-hmm. Putting people at ease, first of all, because even if it's bad news, you're always better off knowing.
Yeah.
And you can, as they say, preparing for the worst is the best possible way of doing it, but working for what you think could be the best possible outcome.
Yeah.
And if you have a plan, doesn't matter where you are in life, particularly if you're a client in our respective fields.
Yeah. Then
getting that advice at the first instance is just invaluable.
Yeah.
Really is.
Yeah. So someone please say, come and give a voluntary interview, and they're like, well, I'm completely, I've not done anything wrong, that's fine, I don't need a lawyer. Is that sensible? Or?
Absolutely not.
Yeah.
I've told you about a few examples where I've taken over cases where clients have just attended because they think, oh, well, I've got nothing to hide. Mm-hmm. I can have a chat with the police and it's okay.
Yeah.
And then all of a sudden reality will hit when they're taken to a police station. Mm-hmm. They're given the caution. Mm-hmm. Yes, of course, they're able to technically leave at any time, but they're being quizzed about matters that they don't know about the law.
Yeah.
They don't know what it takes in order to be able to make out those offences.
Yeah.
And all of a sudden then they're jettisoned upon leaving into the ether, and they're none the wiser, in fact probably more stressed than before they went in.
Yeah.
And all of a sudden they do think to themselves, maybe I should.
It's not really helping anyone either, is it? Because sometimes people can just, we know historically people are quite suggestible and want to pleas and say things that even may not even be true.
Correct.
And
well, look, I gave you an example
Yeah.
when we met about a gentleman, really lovely guy, who had been arrested for really quite serious offences, and he just decided to go with them. Didn't want a solicitor, just spilled his guts. And 2 years on, I did the sentencing for him, mitigated on his behalf. There were serious offences, kept him out of prison, and that was a real risk. Managed to suspend the sentence.
Yeah.
But of course, his livelihood is
Yeah.
now massively impacted, and the right advice at the very beginning would have made a huge difference to his position.
Right, so let's get into some areas of law where there's a bit of an overlap with crime and family, because this is Family Law Cafe podcast, and obviously we're dealing with cases where often there is a criminal element in various ways. Whoever we're helping, it might be on the other side, is on bail, or it may be they've been accused of something. So I think the more knowledge people have, the better, and that's why I do this. So what... have you dealt with cases where domestic abuse has been alleged, and what can you say about that from your perspective?
Unfortunately, dealt with quite a few. I've worked hand in glove with quite a few family lawyers as a result of that.
Yeah.
And unfortunately, both sides of the law, whether it's family or crime, can be used as a way to manipulate the system. And people always say, well, of course, you're going to believe your client, you're their lawyer. But you can certainly see through certain situations as to why matters have been alleged. And so, yes, unfortunately, many. And look, there are a gamut of offences that can potentially be alleged. We've had, over the last 10 years, domestic abuse, domestic violence has been something that has always been in the public eye, but I think certainly a much greater focus has been placed upon it.
Yeah.
And then, 2021, we had the Domestic Abuse Act, and that's really codified that. And it's really quite widely drafted and all-encompassing, and there are a number of offences that I've seen utilised and alleged against partners or ex-partners, unfortunately, with a view to improving their chances in the other sector.
It does seem to be a common feature now in many cases. Can you give me an example of where you think domestic abuse allegations being made and might have been made, perhaps to improve the position in a family case? Do you ever get that?
I have. So I'll give you sort of two examples.
Yeah.
One, let's start at the more extreme. Unfortunately, I'm dealing with a gentleman who, at the moment, is under investigation for historic sexual abuse of his to-be ex-partner. The day that he was arrested was the same day that they had. She had basically told him that she wanted to leave. The subtext to all of this was she actually wanted to remove their child from the jurisdiction, and so the allegation itself, so not only gives her greater ammunition in the family court, but also restricts his ability to move because she wanted to go to the US. So his ability to use the ESCA scheme or even get a visa, even with an interview, be severely impeded. And here we are 2 years later, and we're fighting. We still don't have a resolution. We've done everything that certainly we can in conjunction with his family lawyers to bring it to a close. But then, of course, you have the length of time that investigations take, particularly if you're talking about analysing computers and mobile phones and iPads. So it's a very, very long process and difficult to go through.
Yeah.
And you can see, as I said, that subtext and the application and the usage of that allegation in order to get what this individual wanted.
And how long does it take if an allegation is made of, let's say, of assault? Let's say just maybe it's a common assault, which do you want to describe what common assault is?
Yeah, sure. Well,
it sounds simple, but people might not.
So common assault, a lot of people think that common assault means that you actually have to have hit somebody to actually be charged with common assault. doesn't actually. That
Yeah.
that it can actually just be simply me intimidating you.
Okay.
Could potentially be classed as common assault.
Yeah,
So I don't
wow.
even need to have touched you.
Really?
You have this the secondary element, which is called battery.
Yeah.
But yes, if
And what's battery?
if I that's actually where I were
Yeah.
to lay hands on you.
Yeah.
But yes, I could quite easily intimidate you,
Yeah.
get grit into your face.
Yeah.
Effectively, if you feel intimidated in any way,
Yeah.
that could potentially be classed as
It's
common
got a
assault.
subjective element.
Very subjective.
Yeah, and let's say there's an allegation of common assault. How long would that take to go through the courts? Is that a silly question? Or?
Well, I think it's important
Yeah.
it's important to point this out first of all.
Yeah.
So common assault is triable in the magistrate's court.
Yeah.
Normally, from all other offences, you have to lay the information within 6 months
Yeah.
of the offence actually having taken
Yeah.
place.
Yeah.
But if it's something that comes into under a domestic context,
Yeah.
you technically get almost like an extension of 2 years.
Oh, okay.
So
Really?
yeah, so
Yeah.
what ends up happening is
Yeah.
if that you can basically report that offence as long as it happened within the 2 years prior.
Yeah.
So and then as soon as you report it to the police,
Yeah.
then the clock starts to run.
Yeah.
So you, as I said, you almost get that extension.
Yeah.
And the whole idea is to really create a much stronger framework within which domestic abuse can be reported to the police, which of course works both ways.
Yeah, because people might not report it immediately,
Correct.
and if they later report it, and I mean that's such a simple example. That do you think that if it was in the magistrate's court 6 months or so? Or?
Yeah. So
Yeah.
so to follow and answer your question,
Yeah.
it always depends on how long the trial is going to be.
Yeah.
If it does go to trial, but I would have thought if it's a summary only offence.
Yeah.
Then yes,
Yeah,
somewhere
so
in the region of
Summary
6
only,
months or
that's
so.
just being in the magistrate's court. But if it goes to the Crown Court, how long would that take?
Much longer.
Yeah.
Unfortunately, the Crown Court never really recovered from COVID.
Yeah.
There are a lot of hearings that are done by CBP, which is the cloud platform. But even so, getting a trial date
Yeah.
in the Crown Court for an either way or indictable only offence
Yeah.
will take some time.
A year? More?
I think you need to be prepared for at least a year.
Yeah. And so there might be criminal allegations, and then there's likely to be those allegations in the family court. So the family court being civil jurisdiction, crime being, I think we all know what crime is, but civil being a non-crime, I guess. So in a family court, let's say a woman were raising a number of allegations, they were in the criminal court, and then she probably would raise them in the family court because they would be relevant to child contact, child arrangements. So often people say to me, well, we've got to wait till the criminal case finishes. And I'm like, no. Then we're not going to wait. The civil court does not wait. And so you have these parallel proceedings. Are you in any cases, or have you had cases where there's parallel proceedings? And,
Yes.
and what can you say about that?
To a certain extent, actually, it's the family law side of things that's in control.
Okay.
On the basis that yes, we can make representations, we can deal with the matter.
Yeah.
But ultimately, it's very difficult for us to be able to speed it up.
Yeah.
If that makes sense.
Yeah.
We're at the behest of the police in terms of their investigation.
Yeah.
Once it gets into the court system, then of course we're restricted in relation to what dates are available.
Yeah.
And the first element of that, the police investigation itself, genuinely could take a significant amount of time. The example I gave to you was, waiting 2 years for phones and iPads, seven separate items that had been seized
Yeah.
to be reviewed.
Yeah.
Now, so I would agree with you. You move on with your part because I think it'd be very difficult to simply put your life on
Yeah.
hold.
So if we had to wait in the family court for the outcome of the criminal investigation, it could take a long time.
Yeah.
On the other hand, you have to wonder about, well, it's a different test, isn't it? So in a family court, it will be a balance of probabilities, i.e., is it like to have happened 51%? And so you can get different outcomes, can't you?
Correct.
So,
But
tell me about that.
there is also the issue. So in crime, you have
Yeah.
almost two-stage process.
Yeah.
So in order to charge,
Yeah.
then it is a conviction more likely than not.
Right.
It's the only the test of so that you are sure comes
Yeah.
in at trial.
At trial. Yeah.
And so you kind of morph from similar sort of standard of proof to
Yeah.
what you're talking about
Yeah.
to the much higher standard.
Yeah.
But yes, clearly that could take a
Yeah.
significant amount of time.
Yeah.
So in this example I'm telling you about, ultimately, of course, the client pleaded and I mitigated on his behalf. But if he hadn't, and let's say we had gone to Crown Court trial, him having been arrested initially in 2022
Yeah.
could quite easily be in trial end of 25, maybe even 26.
Wow. So it could have been 3 or 4 years to get to an outcome.
Yeah.
And
2 years just for the police investigation,
Yeah.
at least another year. If you're electing to go to Crown Court, at least another year, maybe 18 months to get a trial.
I mean, there's big delays in family cases, but I think they're not as long as in the criminal case, in criminal
Maybe.
work. And so just to explain to people, civil, as I've mentioned, civil standard of proof. So it could be that in the family court, there's a finding that someone has done something, but in the criminal court, they would be not guilty because it's a different level, isn't it? So what are people told in a criminal case?
As in, what's the standard of
Yeah,
proof?
yeah.
Standard of proof is so that you are sure.
So that you are sure.
Yeah. If there, it is far higher
Yeah.
than on the balance of probabilities.
Yeah.
If you have doubts, then you should acquit.
Yeah. And sometimes I've had been in the family court and had the other lawyer saying, and I'm kind of surprised they even say this, but they say, perhaps I'm acting for the mother, and he was acquitted in the magistrate's court of assault, let's say, and so there shouldn't be a finding of fact in the family court. So in that case, the criminal having happened before the family case. And I've had to say, well, no, because it's a different standard of proof. And, I can remember that being argued, and we kept that one in. And the judge found on a balance of probabilities that the father had acted in that way. So although he was acquitted in the criminal court and he brought that up, it didn't make a difference in the family court. So
It's a difficult position to be in, isn't it?
yeah,
To think that, you've gone through that.
Yeah.
And
then you're going to go through it again.
putting myself in the shoes of the defendant, who's come out what some may determine as victorious, and the relief of that, I'm sure.
Yeah.
To then go through it again and find
Yeah.
it just simply because the standard of proof is different.
Yeah. And but the other thing that is so different, there were 5 allegations, and then he had counter allegations, and there was context. Whereas in what I was told, obviously I wasn't there for the criminal side, is it's a very different setup, because then the complainant, the victim, is represented by someone they don't know. They're brought into court, and then in the criminal court, different things happened. So it's such a different procedure. And they're for different purposes, because one is the punishment of crime and the other one is, to protect a child, to make sure that a party hasn't behaved in a certain way. So the reasons you'd have a fact finding in a family case are, they're not to find anyone guilty, they're not to say they're wrong, it's to protect the child and for the welfare of the child. So the whole thinking behind it is completely different.
And of course you have different rules of evidence.
Yes. Yeah.
Yours, correct
Hearsay.
me if I'm wrong, is a question of weight.
Yeah.
In ours much stricter.
Yeah.
Yes, okay, you can admit hearsay, but there are legal rules and you have to comply with.
Yeah.
Otherwise, it simply won't go in.
Yeah.
And necessarily so, because it is a much higher standard of proof.
Yeah, and a different way. You've got a judge usually dealing with fact finding. In a criminal court, you might have a judge and jury, or you might have magistrates. So it's the same. You can have the same scenario and 2 different outcomes, seemingly, because of a different area, is a different form of law and different standards. So other areas that come in, I'm guessing sexual abuse, historic rape. These are allegations that are really coming to the fore in family cases now.
Yeah, sexual abuse, controlling and coercive behaviour.
Yeah.
And of course that can mean a number of things.
Yeah.
It can mean physical. It can mean emotional. It can mean financial.
Yeah.
The idea that you can just simply control someone in terms of not going out or not socializing with a certain group of friends.
Yeah.
These things do count under that offence.
So tell me, let's look at controlling coercive behaviour, because I think it's really, really important that people understand how that's defined, what that means. You know, you're the expert, you're a criminal lawyer, and the obviously it comes into family law, but from a criminal perspective, how would you describe that offence?
Well, so it is extremely wide.
Yeah.
And I think people need to realise
Yeah.
that from both sides of the angle, actually, it can be simply just sending messages that puts that person down. Or at the other end, it could be, as I said, controlling their finances, or ensuring that they send money to them on a regular basis, or restricting what they do with their finances. It could be in terms of their family, you know, who they can see, who they can't see, and the idea that someone can be in that relationship, and as I mentioned, you have to see it from both angles. You can see that someone who is in that position, and why it necessarily needs to be wide. And on the other hand, you can have the individual against whom it's being accused, and because it's so wide, it means they could be caught.
Yeah. It's. I think there's going to be some processing of this, isn't there? It's an interesting area. Have you represented anyone who's been accused of this?
Yes.
And how's that gone?
Well,
or is it ongoing?
Yeah, ongoing.
Yeah.
I've had a few controlling coercive cases.
Yeah.
But yes, one is still ongoing, and it's a very difficult thing to rebut, because it's quite wide.
Yeah.
And you're going through tons of messages, and this is another thing people, you know, we're just so used to, whether it's using WhatsApp or iMessage or social media, and having to go, you have to go through all of that. And of course, we do it every day, don't we? We send emails, we send messages, and in that context, they're fine, or what we think is fine. But actually, as soon as you put the microscope on it, and it's a case that is not to do with your everyday life, meanings can change. And it's really quite easy to be examined quite robustly in relation to that kind of communication, and it's extremely uncomfortable.
Yeah, interesting. And in terms of the reported cases, have there been many reported cases in this area? I mean, I've seen a few in newspapers.
Reported
Well, it's quite a new offence, and you've told me about the delays. So I don't know how prevalent the offence is, how much it's charged, and how many cases there have been have actually worked all their way through, because it seems to me that it's pretty complex.
Well, one of the problems, of course, is that in terms of reporting, at least, because you're looking in general a summary-only offence, or at least matters that will stay in the magistrate's court, unless they do make it into the papers, then you're not going to pick up on case law, because it's very extremely rare that you can end up with a matter on appeal, for example. But I think what is important is the guidance in relation to not only controlling coercive behaviour, but also the wider umbrella term of domestic abuse.
Yeah.
Because, in short, there are a number of outcomes you can get if you are arrested for any of those offences that come under that umbrella. But the wording under the guidance is, for example, it is rare that a simple caution would be appropriate in a situation that is classed under domestic abuse, which controlling coercive behaviour could be in an intimate setting. And so what that, by virtue of that, says, well, it's either going to be NFA'd, or if it's not going to be NFA'd, you're going to be charged.
So no further action, NFA'd. Yeah.
NFA'd is no further action.
No further action.
Which is, of course, primarily what we try to achieve in every case. Of course, it's not always possible. But that tells you really the emphasis. The driving factor is, we want to toughen up on domestic abuse, which, of course, in certain circumstances is absolutely right. There are plenty of people who suffer. But conversely, what it also does is, once the wheels start to turn, it's incredibly difficult to stop them. And if we're talking in the context of allegations potentially being made in order to assist you in other areas, and a perfect example is, someone makes an allegation, the individual suspect is then interviewed, they're bailed, all of a sudden they're given bail conditions. They can't attend the family property. They can't see the individual. They can't go within a certain distance.
Yeah, which affects the family side.
It all just affects the family.
Yeah.
And then all of a sudden, the individual who's made the complaint says, "Oh, no, I don't want to proceed anymore." Of course, the guidance is that, well, a view will be taken, but it's not the complainant's role to make that decision.
Yeah, because this change was made so that even if the person who'd made the complaint decides they don't want to proceed with it, it can carry on.
Correct.
And it should carry on, I think, is the
And I did one literally just the end of last year, where precisely that happened. And the CPS summoned the individual who made the complaint.
Oh, I see. So the person made the complaint, didn't want to proceed with it, and then was summoned and made to give evidence.
Yep.
How did that go? Do you know?
We were acquitted.
Yeah.
Because
it's
of course,
an unwilling witness.
Unwilling witness, but gave evidence,
Yeah.
and ultimately, they had a retraction statement. Now there are always a number of reasons as to why that retraction statement can be provided, but ultimately it's good evidence for us.
Yeah.
But it shows, as I said, once you start the wheels, especially if it has been utilised for ulterior motives, it's very difficult to stop.
Tell me about malicious communications. What does that mean?
So, funny enough, I've literally just done one.
Yeah.
And this could be, it's come across anything. That could be email, that could be text, that could be phone call, that could be social media.
Yeah.
And it's effectively sending unwarranted and unwanted correspondence to that particular individual, causing alarm, distress. And this precisely happened in this case where my client was accused of sending malicious communications.
Yeah.
It was one message over social media.
Yeah.
The precursor to that was their ex-partner had in fact been arrested and previously bailed for domestic abuse.
Yeah.
And so, funny enough, reverse engineering it, they ended up on the receiving end of an application for a non-molestation order because of that allegedly malicious communication.
Yeah.
So, that's again, it goes back to the point of when you put words in under a microscope in isolation, then to a certain extent you can almost make them say whatever you want them to say.
But are they not context dependent? Even if it's in court, do you not say, well, this person posted this on social media, but the context was this? Is that not a defence you can use?
Absolutely, context is vital. But just looking at the message itself, if it can be construed in a way that was malicious and was intended to be so, then you can potentially have a problem.
Yeah. Because there's so much communication, isn't there? And when was that? When did that come in? Malicious communications? Is that an old act?
You're testing me now.
Yeah, no, I kind of am.
A few years ago, I off the top of my head, I don't remember the year of the act.
I just remember years and years ago doing a trial, and it was between neighbours, and it was sort of a poison pen thing of letters, and they were completely and utterly outrageous. And I think it started as a family case, and it was just all this for some reason. Yes, that was right. It was a family case, and then there were issues with the neighbours who didn't like this new relationship. I think the situation was it was a man and his wife had passed away, and he'd entered into this new relationship really quickly, and the neighbours didn't like it, and it was just all got involved, and then this woman started receiving awful letters, and a brick came through the windows. It was very nasty, and it was a private prosecution, I think. And I just remember the just reading out these awful things, and the defence was, well, it's just the way I speak, but they were awful.
But then it becomes
convicted.
Then ultimately it can morph from malicious communications to harassment.
Yes, exactly.
Because if it then becomes a course of conduct, and especially if you're talking about physical damage and criminal damage with the brick going through the window, etc. Then that'd be certainly easier to prove.
Yeah, just remember that. Just like that's just the hearing the brick was just so awful. This whole campaign. What is harassment? What's the definition of harassment?
So it has to be a course of conduct.
Yeah.
All right. With the intention to cause harassment, alarm, or distress.
Yes.
Yeah.
Okay.
So again, relatively wide.
Yeah.
It's both subjective and objective.
Yeah.
So it will be looked at in the latter first, but that individual ultimately is able to give their evidence, and that's how they felt at the time.
Yeah.
Then it can potentially be charged under that. Yeah.
And so that might be lots of text messages. Sometimes we get cases where someone's received 44 text messages in 10 minutes, and that could be harassing, presumably.
Potentially.
Yeah.
Normally, ultimately, there is a mental element to it as well. And so, especially if there has been a conscious decision or communication from the victim to say, please don't do this, I don't want you to do this anymore,
Yes,
and it continues,
yes,
then it's relatively easy to prove.
yeah,
And in fact, I did one last year, an individual who had met another person on a dating app,
yeah,
and somehow got it into their head that that person was not in fact really there to meet their next boyfriend or girlfriend. They were there to effectively try and extort them out of money. And for whatever reason, they decided to continuously send this individual messages, telling them so, and that the kind of person they were, and ultimately, my client was wrong. The person was not that at all, and so ended up being charged with harassment.
And you get a harassment warning, can't you? So if you got if someone was receiving all these messages and you went to the police, as I understand it, they would warn first of all, or would they just
No, not necessarily.
Okay.
Very much depends.
Yeah.
This individual was charged.
Yeah.
Yeah.
Okay. And there's a Protection from Harassment Act, isn't there? There's a Civil Act. So there's a bit of overlap, isn't there, from the civil side, and of course, non-molestation orders. So very much known about in family law, non-molestation occupation orders, and you have zonal non-molestation orders. So non-molestation, I think it's a bit of I'm surprised that they haven't changed the name of it, because lots of people will say to me, they think molestation means something sexual, and it doesn't. That's often been said to me. I'm not molesting, because obviously molesting a child, I'm a child molester or something like that. So that's in their mind. But non-molestation order means just don't bother them, I suppose, almost at its lowest.
It's
just
basically
leave them
a
alone.
non-contact order.
No, it's pretty much that. The safest thing you can do is go no contact.
Correct.
And it's just a way of protecting. And they are quite easily handed out, I'm going to say. The more difficult one is if you want to get the person out of your home. So say it's a couple living together, the marriage has come to an end, they've stayed in the same property for, let's say, a year. And it's not the most sensible position, because obviously there's a reason they're getting divorced and tensions run high. And sometimes people are absolutely desperate to get the other person out of the house, but it is really difficult.
Which, if I can interject there,
please.
which is a perfect opportunity if you are trying to achieve that.
Yeah.
If you do make an allegation that falls under the Domestic Abuse Act, then the individual making that complaint about could end up with a notice under that act.
Yeah.
Which is the test is reasonable belief of the police officer that that act has in fact happened.
Yeah.
And secondly, the reasonable belief that the notice is necessary.
Yeah.
So reasonable belief is relatively low threshold in order to be able to obtain. And as part of that notice, the suspect could be prevented from being in that.
Is it that just for 28 days, or is it an ongoing thing?
It's notice is ongoing.
So the police can give
and of
that.
course, so you can have the notice, and then that's effectively that's a position to say, look, you need to leave. Of course, if the investigation is continuing, then you can end up with bail conditions.
Yeah, yeah.
So it is a way to almost get round that idea of having to go and make a proper application to court.
Yeah.
Because the police will see things a little bit differently, dare I say it, than the judge would.
Yeah, I don't see lots of police use of those notices, but do you see a lot of it? You might do.
Some.
Yeah.
But in general, they find it difficult to deal with things summarily, which is almost basically what that notice is.
Yeah.
They would prefer to bail.
Yeah.
Investigate.
I see a lot more of, bail conditions, and then the person has to leave.
Yeah.
And that's pretty common. And the bail conditions, so just to deal with something else that often happens, is someone might have been arrested, so they bail conditions, they have to leave the home. And then it is useful then to get the non-molestation, if you haven't got one, to get one, just because those bail conditions could stop at any time. So you don't have to sit and wait, you can get a non-molestation order, and usually that will be granted.
And I would have thought that
Yeah.
the fact that bail conditions are in place
Yeah.
would be, good evidence to show
Yeah.
that non-mol should be.
But sometimes people get confused and think, well, we just have to wait to the end of the bail conditions. But they are, again, two different, they're there for different reasons. One is about, is it that protecting, it's really preserving evidence in lots of ways, isn't it? Because the bail condition might be not to contact that person. And so it's to preserve the evidence for that case and the possible charge and the possible to go on to have a trial, whereas the non-molestation and occupation order is to it's a civil way of just keeping people apart. It's not leading to any charge, and it's often judges will say, well, a non-molestation order, that's fine because I'm only stopping someone doing something they shouldn't do anyway. So all the terms of a non-molestation order are pretty much not to commit a crime. So they're not difficult to grant. Whereas an occupation order means that someone has to leave their home, and the courts are not so willing to grant that because that's an invasion of their kind of rights, their property rights. A few years ago, they changed breaches of non-molestation orders to become criminal. I have an opinion about that, but I don't know if you ever represent people about, who've breached a non-molestation order and how that goes.
In a non-molestation from the family court,
Yeah.
I've never represented
Yeah.
someone in that respect. It's always been as a result of being arrested for other offences.
Interesting.
But it is interesting the fact that it's shifted in terms of the severity of the ramifications of breaching.
But that's a criminal offence. And it's interesting, isn't it, that you haven't, and because, coming to my view of this, that it used to be the case that a breach of a non-molestation order was a civil matter, and the judges would deal with it pretty. You had to prove it beyond reasonable doubt, but usually you would be able to. Let's say the non-molestation order said you're not to text, telephone, or whatever, and so then they send a text. So it's not that hard to prove, and so then that would be dealt with fairly briskly, and the court might just send that person down for 14 days because it was a contempt of court. But what I find now is there is a reluctance to charge for breach, and I just wonder if police, because it is a really serious offence, and I've seen outcomes where someone's been charged with breaching a non-molestation order in the magistrates' court, and the magistrates have acquitted them, and it makes no sense because, for example, they sent that text. So they can't. That's just mitigation. If they say sometimes, well, sending a text would be difficult to do unknowingly, wouldn't it? But I have seen them be acquitted, and I just wonder if, by mistake, that I just feel it worked better the old way.
I mean, as I said, I haven't dealt with an individual as a result of that.
Yeah.
But I have dealt with quite a few that have breached their bail conditions.
Yeah.
And there, the magistrates do take it extremely seriously.
Yes. Yeah.
And you're more than likely to be remanded if that is what's happened.
Yeah.
And in fact, actually, that's precisely what happened when, in the matter I told you about with the individual who retracted their evidence and then ultimately was given a witness summons. My client was looking to collect their children. They weren't supposed to go within a certain radius of the home. And did so. The complainant reported it to the police, and they were arrested and put in custody. I had to go look after them the following day. So
Yeah. Well, you can see why, because they've made the bail conditions, and so that's why they would enforce them. And I think my previous point was about that the civil court had made the non-molestation order, and that is why they would say, you've breached that, it's in the same court. And somehow I just feel, but I may completely be wrong on this, that you're going between a civil court and a criminal court, and they don't always understand each other.
I think that's right.
Oh, good. Right. So, any other areas where you feel that your work intersects with family, and how do you, if that happens, do you work with family lawyers? Because often we have cases where we'll say, okay, you need to get a criminal advice, you need to get advice from a criminal solicitor on this, and, we get it quickly. So how do you work with family lawyers?
Yeah, I mean, I think that's absolutely vital.
Yeah.
People say, well, of course you're going to say you should get advice as early as possible.
Yeah.
But honestly, it's the only way to do it. It puts the client at rest as much as they can be in what is definitely going to be a tumultuous time, whether you're dealing with family or criminal matters or both.
Yeah.
And having that idea that you can work together.
Yeah.
Because ultimately, I'm not a family lawyer.
Yeah.
Yes, I have broader understanding of the admissibility of evidence,
Yeah.
etc. But I don't really know how it works,
Yeah.
other than by osmosis from having worked with family lawyers.
Yeah.
And likewise, it works vice versa.
Yeah. Yeah.
So having a team around you that can, as well as possible,
Yeah.
explain to you not only the structure, but a strategy as to how to achieve the best possible outcome from the outgo is just, it is invaluable.
Yeah. Do you ever need papers from a family court? Have you ever done that? Because I've been in a family case where someone's come and said, look, we want these papers in the criminal case, and they come and make an application to court, and the family court doesn't want to dish out everything, but it would dish out some things if they're needed. So have you ever
Yeah,
had that
and yes,
experience?
exactly that. Like that, the justification is incredibly
Yeah.
important.
Yeah.
You do need to make the application properly, and you need to be quite targeted.
Yeah.
Ultimately, it can't just be a broad brush approach. Well, we just want everything. You have to justify precisely why. So it's not straightforward, but yes, it's possible.
Yeah. So thank you, Oliver, for coming along. I feel that I completely agree with you that we have to work as a team, and it's really, really helpful for when things happen, with the criminal context in my family cases, to be able to get hold of a criminal lawyer and just say, this person needs help, and to be able to send them really, really fast. I mean, for example, we had someone who just got arrested with 6 officers, and it was nothing. It was I would call a malicious allegation, but had she not had the reassurance of knowing that she had a criminal lawyer, if she had been questioned, I think it would have been really, really harsh.
Yeah.
So thanks for all the information you've given us.
Welcome.
Any sort of last things that you would want to say to anyone that finds himself, anything that vaguely they're worried about in criminal context? What's the top advice? What are your tips?
Don't Google, because the chances are you'll end up scaring yourself more than you need to.
Yeah.
And just take the time to speak to someone on an initial basis.
Yeah.
And that works for almost any area of law. But let's face it, when you're talking about the family or crime, then you're talking about a huge amount of emotion, finances, and ultimately, of course, in crime, you can potentially talking about liberty.
Yeah.
And that's to at least get someone who can plot out that map from the very beginning. I think it just really helps. You sort out things in your mind, because you're going to be all over the place.
Yeah.
That's just we're all human, and I can say that even as someone who's practiced for a number of years, if it were to happen to me, I would feel like that. So that would be my top tip. Really, just go and have a chat, even if it's just for an hour.
Yeah.
Just tell them everything they need to know, and you'll get the right guidance.
Get that early advice. And where do people find you?
So my office is based in Green Park.
Yeah.
So not too far from you.
Yeah.
You've got my details, and always happy to have a chat, and as I said, try and put people's minds at rest.
Cool. Thank you so much.
Thanks, Joanna. Really appreciate it.